Hi, I'm Jonathon Kappy.
And I'm Stuart Clark.
Welcome to Holland Estates. You're listening to the next episode of our weekly podcast.
We're still coming to you from the land of quarantine, or land of home work during this COVID time. So it's good to see you, even if it is remotely. Now, it's been a while, but hello.
Hello from home.
No, exactly.
So today we are going to talk about pour-over clauses. And in particular, we're going to start our discussion with the decision of Quinn Estate and Rydland, which is a decision that came out of the Court of Appeal in British Columbia. The facts are relatively simple, but the legal issues that pour out of it are a little bit more complicated, and that's why we want to talk about it.
Pun fully intended, I am sure. Pour-over clauses might be one of the more strangely, if not worst named kind of concepts of estate and trust laws. It kind of sounds like it's some, I don't even know what it sounds like. But the basic concept is, can you, in a will, leave a bequest to a trust, an inter vivos trust that already exists before you die? Basically, could you set up an inter vivos trust called, the Smith Family Trust during your lifetime, and then in your will say, well, I want to give everything in my estate to the Smith Family Trust, and then in theory, the assets would then be administered in accordance with the Smith Family Trust, or whatever the heck you want to call it. And I guess they call it a pour-over clause because the assets pour over into the other trust. And it's a concept which, according to Quinn's decision, exists in other jurisdictions. The U.S., it appears, it's fairly common in the U.S. to allow this kind of bequest, but that in Canada and in the U.K., it's a little bit more dicey.
So the facts of this particular case really highlight some of the problems that arise with pour-over clauses. It is more of a U.S. concept. They have specific legislation in the U.S. that deals with pour-over clauses, and this particular was written by an American attorney, which is probably why it ended up in this will. But when this will was drafted, the residue of the estate was left to an existing inter vivos family trust. Now, the terms of a family trust was that the trust was, number one, amendable, and number two, revocable. And that was sort of the key reasons why the courts had trouble with this residue clause.
And as Jonathan said a second ago, in this instance, the trust itself was unilaterally amendable by the settlor. And that's kind of where the court kind of rested its hat on why they didn't like this particular clause. Although then it kind of did a deeper dive on some of the other reasons where even if that didn't happen, maybe it would still be a little bit dicey. But the basic issue that the court had with the fact that the trust was amendable was they were concerned that it could basically allow a change to your testamentary plan after the will was signed that would not be in compliance with what otherwise is fairly strict amending language, right? So normally, if you do a will, it has the very strict requirements. You have to, have it signed in the presence of two witnesses who must sign it with you. And then when you amend a will or do a codicil, you have similar kind of very strict requirements typically. Well, the concern would be, well, if you do a will that says I leave everything to a trust, and then that trust has its own language that says, well, you can change this trust whenever you want, for whatever reason you want, to do whatever you want. Well, basically, you're leaving assets to something that could be changed, which wouldn't comply with strict requirements that may otherwise exist. And the court doesn't like that.
Yeah. And so that was the first issue that the court took, was that, you're allowing someone to change their testamentary disposition without the formal requirements of a will. And I actually believe that this will was drafted while British Columbia was still in a strict compliance regime. And the second problem that the court had was that because the trust was amendable, the court couldn't necessarily identify with certainty the actual disposition to be made. So in this particular case, the trust was actually amended after the will was made. So you had terms of this trust when the will was drafted, and subsequent to the drafting of the will, the terms changed. So in fact, what the testator intended to do when he signed his will was not what was going to result by the time he died, because the terms of the trust had changed. And I think that was the second biggest reason the court was really taking issue with this clause. Was this will carrying out the testamentary intention of the testator? And in wrestling with some of the legal issues and trying to uphold it or determining whether it should fall, that was certainly one of the reasons that the court referred to.
And kind of going through the analysis on that point, and what was the intention of the testator at the time, because what matters when the will was signed, right? So when the will was signed, you understood that the trust did X. But then if the trust later does Y, well, when you sign the will, did you actually understand, was that your true intention, right? And that's kind of the whole issue here, where you can amend a trust after the fact and you amend your testamentary plan in a way that may not have been contemplated at the time that you signed the will, and therefore we don't like this. But in kind of jumping through the, well, let's do a deeper dive on the concept of, do we like these kind of pour-over clause languages? The court gets into the concept of incorporation by reference, which I think is kind of an interesting kind of, area to kind of think through in trying to understand some issues with this kind of, pour-over clause concept. So for those who don't know, incorporation by reference is a fairly standard or fairly common estate planning tool. You most often see it in reference to memos. So you'll see in a will something like, I want my personal property to be distributed in accordance with the memorandum that I have prepared. And then, they'll prepare some long memorandum saying, my figurines to my grandkid and whatever the heck it says. But an important part or concept of the incorporation by reference is the fact that the document itself has to be in existence at the time the will was signed. So you can't say, I'm going to in the future do a memo. That's not cool. The memo has to exist already, and then it's incorporated in, which obviously in the case of an amendable trust, is not really, possible because you can change it after the fact. But also interestingly, and ultimately why the court said incorporation by reference shouldn't extend to pour-over clauses, was because when you're using the doctrine of incorporation by reference, what you're actually doing is pulling in that outside document to be read as if it's part of the will, hence incorporation, air quotes again. So in the memorandums case, you're literally pulling in, my figurines to my grandkid as if it's a clause in the will. Well, when you say, I want my residue to go to the Quinn family trust, you're not really intending that then the terms of the Quinn family trust are going to get pulled into the will and read verbatim as if it's part of the will. It's not saying, and my trustee shall have the following powers and you can pay compensation. No, what you're really doing is you're wanting to give money to that separate entity. So you're not really trying to incorporate the concept of the trust into the will, therefore the doctrine isn't available here, which I thought was kind of an interesting kind of concept that takes a step back and basically realize, oh, you're right, yeah, you can't really incorporate the trust into the will because that's not what you're trying to do here. You're just trying to give money to that trust, which the court doesn't love.
And listen, you were absolutely right from the very beginning. It was, that incorporation by reference was a dead issue from the very beginning because the document had to be in existence at the time that the will was signed. And in this particular case, given that it was amended, the trust was amended after the will was signed, meant that it couldn't possibly have been referenced at the time of execution.
Exactly. So here, all roads in this instance lead back to the court wasn't going to let this happen because the trust could be amended and in fact was amended after the fact. Mm-hmm. I guess that raises kind of interesting hypotheticals around, well, what would happen if the trust couldn't be amended after the fact? And I guess the answer would be, well, the court doesn't definitively answer it here, but proceed with caution, red flags all over the place. Because, trusts by their very nature can be amended even if the trust itself doesn't say it can be amended, right? The rule in Saunders and Voce, the Variations of Trust Act, all create regimes under which trusts can be amended after the fact, even if the trust itself doesn't say it can be amended. And the jurisprudence is kind of iffy at best, we'll call it, in Canada on whether or not, over whether or not pour-over clauses would ever be possible.
Yeah, it's until legislation comes into effect, it would certainly be my recommendation that if you want to leave money to a trust, create a trust in your will and have all the terms of that testamentary trust in your will. And even if you end up with multiple trusts running concurrently for the same purpose, don't let money from one estate pour into another because there's potential for disaster. Exactly. And you're really trying to walk between the lines, I think, to make sure that it's not invalid and you end up with a partial intestacy, which is what nobody wants.
Exactly. So in this instance, as if, we haven't cut on already, the court said, no good, no pour-over clause doesn't work here and declared that the bequest was invalid.
All right. Well, Stuart, that was great. It was great to see you. It was great to discuss some law for the first time in a couple months. I want to thank those of you for watching and listening. And until next time, I'm Jonathon Kappy.
And I'm Stuart Clark.
All right. Take care. Goodbye.
Thank you.